Good evening, everybody. Daniel Sherman here. This will probably be one of my last criminal videos for a little while at least. I'm going to start doing some of the domestic questions that people have. But I do want to talk today about there was a case called Miranda versus Arizona and what that means. So many people have heard of your Miranda rights. Police, usually they memorize, and sometimes they'll read from a card. They're just saying, hey, look, you have a right to an attorney. You don't have to talk to me. If you do talk to me, it can be used against you in court. That's your basic Miranda rights. The question I get all the time is, hey, the cops didn't read me my rights. What does that mean? I think a lot of clients think it just means, well, they're just going to have to dismiss the case, and that's just not the way it is. So, the way Miranda rights attach, that means where they actually have to read them to you, where it becomes important, is number one, if you are in custody, and number two, if you're being interrogated. So, I guess the question of custody. You'll see, I guess, a lot of YouTube videos where, people say, am I free to leave? Am I free to leave? Am I being detained? And, the reason they're asking that question is because, it may trigger custody. You're being in custody. And I will say this, a traffic stop or a DUI stop is not considered a custodial interrogation. So they don't have to read your rights when they're saying, hey, do you know why I pulled you over? Get out of the car and then start asking you questions about, what you've had to drink, what controlled substance you may be using. They don't have to read you your rights. There's a case specifically says that is not a custodial interrogation. So, when are you in custody? If you're in the back of a police car, you're certainly not free to leave. If you're in the jail cell, you're not free to leave. If you're taken to the police station for questioning and you say, hey, look, am I free to leave? And they're like, no, you're not free to leave. You're in custody. So that's the first element. The second element is, are you being interrogated? Are they asking you questions? So a lot of my clients just won't shut up. They say the right to remain silent, but not the ability. And they just want to talk about everything and, incriminate themselves and, sometimes incriminate their friends or their buddies. I just say, be quiet. I had a former sheriff one time tell me, Daniel, if people would just be quiet, like we wouldn't solve 90% of these cases, or at least 90% of them wouldn't even be charged. They just be quiet. That's really what you should be doing. But that's kind of the point of Miranda, is to tell you, to be quiet. And the Supreme Court in Miranda versus Arizona specifically said, look, when you're in custody, you're stressed out, you're under a different circumstance. You really need to be reminded of your rights. And so that's why the custody is important. So again, with the interrogation, if they are, basically if they're asking you questions, if it's an investigation, they, come by to your house and, say, hey, look, if it's your parole officer, because you're not free to leave with your parole officer there, and starts asking you questions, I would say there's a good chance you're in custody and they're asking you questions that may, hey, look, are there any drugs in the house? You need to tell me right now. I mean, you're not free to leave. Hey, parole officer, I'm going to walk out. They're going to arrest you. So that's a good example of an interrogation in custody. The classic one is, when they go see you at the jail, or, when they bring you in for questioning. And, almost always they're going to, they're going to read you your rights before they question. They're smart enough to do that. But, there are some times and some circumstances where you do get some issues where people, are in custody and then they start talking, which wouldn't trigger Miranda. But then the officer starts asking questions. And so that's kind of where you're kind of drawing the line. So the real issue is, if your rights are supposed to be read to you and they're not, what does that mean? Basically, it means any statement that you use or that you say. If you say, "Hey, look, man, I got a body in the trunk of my car," they go based on that evidence. They get a search warrant. They search your car, the trunk of the car. They find a body. Oh, okay. Well, if they should have read your Miranda rights, then the statement, "Hey, by the way, there's a body in the trunk of my car," can't be used against you. Now, there's maybe a different question as to whether or not they could have got the search warrant, because that was based on what's called the fruit of the poisonous tree. So they wouldn't have got the warrant, more than likely, if you hadn't talked. I guess another argument would be, well, we have what's called the inevitable discovery doctrine. Well, they would have found it anyway. They could have ran a police dog, or, what are you going to do with the car? So there's an argument maybe the search warrant still would have stayed. But if you're not Mirandized and you say something incriminating, that can't be used against you. And sometimes you're not even saying something incriminating. If I try cases, sometimes it's not necessarily incriminating, but it just doesn't sound good, to a jury. And so you want to get that evidence out, even if it's not, "Hey, I did this." If they're telling a story, especially that's just not true and just can't physically happen, you don't want a jury to be like, "Well, the guy's clearly lying." So you want that statement to come out. So that's the important part of Miranda versus Arizona, and your Miranda rights is basically they cannot be used against you if they are not read to you, if you're in custody and there's interrogation. And again, there's a bunch of case law that defines that. I'm trying to give some pretty simple examples for you. I'll tell you a case I had. I was practicing for a couple years. I represented this guy, and he had fled to California, and they went and they picked him up. And as they're driving through Arizona, the guy starts to talk. And then they start asking him questions. And before they go any further, they stop and they call the Commonwealth attorney in Hopkins County, who at the time was is a judge now, Judge David Massamore, and say, "Hey, should we Mirandize this guy?" And the judge now, so I'm referring to him as Judge Massamore, said to them, "Yeah, you're in Arizona. The case Miranda versus Arizona means you need to read it to him." So, they read it to him, and, he talked. I think he even made a written statement. He was later convicted. He was probated, eventually, and, he completed his probation. He's doing really well now, so I'm really proud of him. But, he had some issues when he was younger. He was 20, 21 years old when he did this. So that is, my personal experience where it clearly had happened, and the Commonwealth attorney gave the right advice to the police, and that was was able to use against my client. Okay, well, I hope you all have a good night. This video probably won't be posted by the time I upload it till Monday morning. I'll be in court all day Monday. But if you do all have any questions, you got my phone number. It's on my Facebook page, and if you have any comments, I've tried to respond to them. There's been a few. I appreciate the comments, appreciate all the support. And again, if you all need anything else, just let me know. So you all have a good night. Take care.